Welcome to the Deep Dive. We're continuing our exploration of the Manual of Patent Examining Procedure, the MPEP.
Right, your guide to the patent process.
And today we're zeroing in on a specific part. Think of this as getting the key insights straight from the source.
Exactly. We're diving into Chapter 2100, which is all about patentability.
And within that,
Section 2148, this section deals with form paragraphs, specifically the ones examiners use for obviousness rejections under the pre-AIA 35 U.S.C. 103.
okay, pre-AIA 103. So the rules before the America Invents Act changed things. And 2148 gives examiners standard text for those rejections.
Pretty much. It provides standardized templates. It's all about ensuring consistency when they reject claims based on obviousness, arguing that the invention would have been obvious to someone skilled in the field at the time.
So it's not just a random opinion, there's a structure.
There is. And understanding these paragraphs helps you, the listener, see exactly how examiners structure these crucial rejections under those older rules.
It's like seeing the playbook. So understanding Section 2148 gives you insight into the examiner's reasoning for pre-AIA cases.
Precisely. It helps decode why they're saying an invention might not be, well, inventive enough under the old standard. And remember, this whole series covers every section, chapter by chapter.
Great context. Let's get specific then. Form paragraph 7.20.FTI. What's its job?
Okay, 7.20.FTI. Think of this as the foundational statement. It's where the examiner formally cites the law itself, pre-AIA 35 U.S.C. Section 103A, as the statutory basis for the rejection.
So step one, state the law being used.
Exactly, laying down the legal marker.
And when does this paragraph typically show up?
You'll usually see it right at the beginning, either in the first major response from the examiner, the first action on the merits, or if things aren't resolved, it'll be in the final rejection too.
Makes sense. Sets the legal stage clearly. So what follows that? Form paragraph 7.21.STI.
Right. 7.21.FTI is the next logical step. This is where the examiner actually makes the rejection concrete. By citing the specific prior art, the patents or publications they believe show your claimed invention was obvious.
Okay, so 7.2.FTI says why legally, and 7.21.FTI says what evidence shows it.
Exactly. And crucially, this paragraph must come with an explanation. That's per MPEP Section 2144.
An explanation.
Yes, the examiner can't just list references. They have to explain why combining them, or looking at one, would lead someone skilled in the art to your invention. The reasoning is mandatory.
Got it. You need the why. Now, what about 7.2.FTI and 7.2.02.FTI? Sounds like they handle specific inventor situations.
They do. These deal with trickier scenarios under pre-AIA law, specifically Section 103C. They address situations involving, say, joint inventors or inventions that are commonly owned, like by the same company.
And how does that affect obviousness?
Well, under those old rules, certain prior art might be disqualified, meaning it couldn't be used for an obviousness rejection if it originated from the same inventive entity or commonly owned group.
Oh, interesting. So your own team's earlier work might not count against you sometimes.
Under specific conditions, yes. These form paragraphs, 7.20.01 and 7.20.02, are the tools the examiner uses to sort out whether that prior art is actually disqualified under 103C because of those relationships.
Okay, that adds a layer. Now, form paragraph 7.20.05.FTI Joint Research Agreements and the CREATE Act. That sounds complex.
It can be. The CREATE Act tried to address how prior art is treated when it arises from collaborative research between different organizations.
Like universities and companies working together.
Exactly. So form paragraph 7.20.05.FTI is used when an applicant tries to argue that a piece of prior art shouldn't be used against them because it came out of a formal joint research agreement they were part of.
So trying to disqualify the art based on collaboration.
Right. But the paragraph also points out why these arguments often fail.
Oh, how so?
Applicants might not properly document the agreement, for example, or they might not clearly show their invention actually resulted from activities within that specific agreement's scope. You need proof.
So just saying we had an agreement isn't enough. You need the details in the link.
Precisely. The form paragraph essentially tells the applicant, here's what you need to show us if you want this CREATE Act protection to apply.
Makes sense. Okay, moving to form paragraph 7.21.01.FTI, provisional rejections. What does provisional mean here?
Think of it as a potential rejection or heads up. It happens when the examiner cites art from another patent application that's still pending it, hasn't issued as a patent or been published yet.
But it could become prior art later.
Exactly. If that other application eventually publishes or issues and its date is early enough, it will become prior art against your application.
So the examiner is saying, watch out for this one.
Essentially, yes. 7.21.01.FTI gives you advance warning. It lets you know about this reference that might be used against you down the road, giving you time to think about arguments or amendments.
That seems helpful, actually. Avoid surprises. What about combining references? That's form paragraph 7.22.FTI, right?
Yes, 7.22.FTI is for combining multiple references. Very common in obviousness rejections.
Because one reference rarely shows everything.
Often, yes. So the examiner might take reference A, which shows feature 1, and combine it with reference B, which shows feature 2, to argue that putting them together would have been obvious.
The further in view of rejection.
That's the one. And again, just like with 7.21.FTI, the examiner can't just randomly combine things. They need a solid rationale. They have to explain why someone skilled in the art would have been motivated to combine those specific teachings. 7.22.FTI sets up that explanation.
Okay. So we've seen paragraphs for the legal basis, the specific art, special circumstances like joint inventors or research, provisional issues, and combining art. Looking back, what's the big picture here with Section 2148?
The main point is structure and consistency. These form paragraphs show that examining for obviousness under Pre-AIA 103 isn't arbitrary. It follows a defined process based on the statute, the facts found in the prior art, and procedural rules.
They provide a framework.
Exactly. A framework for the examiner to follow in making the rejection, and just as importantly, a framework for the applicant to understand and respond to that rejection.
Understanding the structure helps you craft a better response.
Absolutely. It helps you target your arguments more effectively.
So if you get one of these rejections using these paragraphs, what can you actually do about it? What are the options?
Well, the MPP points out a couple of key mechanisms. One is Rule 131, often called swearing behind or antedating the reference.
Antedating, meaning showing you invented it earlier.
Precisely. You provide evidence, like declarations or dated lab notebooks, to show you completed the invention before the effective date of the cited prior art reference. If successful, that reference is no longer prior art against you.
Okay, that's one route. What else?
There's also Rule 132. This allows you to submit evidence, usually declarations or affidavits, to attack the reference in other ways. For example, arguing the reference was actually derived from your own work, or that the reference doesn't qualify as being invented by another under the specific pre-AIA rules.
So, different ways to challenge the applicability or the date of the prior art.
Right. But both require strong evidence and clear arguments tailored to the specific rejection you received, which, again, is framed by these form paragraphs.
Very helpful. Before we wrap up, some important points.
Yes, definitely. We absolutely need to thank Mike Shepard. He's the creative director who organized this whole project. This educational audio series on the MPEP wouldn't be happening without him.
Absolutely. Thanks, Mike. And now, the necessary disclaimer.
Right. Please remember, the summary covering MPP Section 2148 was put together using AI tools like ChatGPT and NotebookLM.
And while we aim for accuracy, there could be errors or omissions.
It's really for general educational and informational purposes. It is definitely not legal advice, and it's no substitute for proper training.
For any authoritative guidance, you absolutely must consult the official MPP itself, talk to a qualified instructor, or get advice from a registered patent practitioner.
Please do. Hopefully, though, this look at Section 2148 gave you some useful insights into those pre-AIA 103 obviousness rejections and the form paragraphs involved.
I think it did. It really shows the level of detail and structure in the examination process. And we really encourage you, if this is relevant to you, to explore the full MPEP for a deeper dive.
And maybe a final thought to leave you with. How do you think this kind of standardization using these specific form paragraphs actually impacts the consistency and maybe the predictability of patent examination outcomes under those pre-AIA rules?
That's a great question. Does standardization lead to fairer, more predictable results, or could it sometimes limit nuanced analysis? Something to think about.